of constitutional norms, even when political exigencies tempt us otherwise. This is what I was talking earlier. And this is what Dr. B.R. Ambedkar has emphasized, that really a political party having majority in the parliament is not free to change the basic structure of constitution. It means honoring diversity rather than suppressing it. It means privileging the spirit of the constitution over temporary political interest. As we contemplate synchronized elections, we must ask, does the proposal strengthen constitutional morality or does it challenge it? Further, it becomes important to look beyond Indian constitutional practice and consider comparative experiences worldwide. Democracies everywhere have faced the challenge of synchronizing elections, balancing stability with accountability, and aligning federal aspirations with national unity. Yet, their solutions are shaped by unique political cultures, histories, and constitutional philosophies. Thus, foreign models cannot simply be transplanted without assessing their suitability to our own context. This is very important. Only because Germany is having it, only because Spain is having it, we have to bring it to our country. That cannot be. We have to see that in present context, whether it will be feasible to introduce that pattern. Countries such as Germany, for instance, operate under a carefully structured parliament system that incorporates the constructive vote of no confidence. This mechanism ensures that instability does not lead to abrupt solutions. But Germany is relatively a smaller federation. Spain too uses a constructive no confidence motion, but Spain autonomy model, though decentralized, operates within a uniform electoral cycle. Similarly, South Africa employs a hybrid model where national and provisional elections are held simultaneously, meaning thereby at the same time. But that is in part because South Africa's provinces do not possess legislative autonomy comparable to our state. These differences underscore a crucial reality that India's federal diversity is unique. India can rightly be described as the world's most heterogeneous society. Supreme Court further categorizes the Constitution of India is differently described more appropriately as quasi-federal because it is a mixture of federal and unitary elements leaning more towards the latter. Our states possess constitutional status, legislative authority, and political distinctiveness that cannot be subsumed within a single template. Another dimension emerges from the intersection between synchronized election and the constitutional principle of separation of powers. The model code of conduct constraint on governance actually represents a carefully calibrated balance between executive authority and electoral integrity. Critics argue that repeated elections impose repeated pauses in governmental decision making. Yet, it must be understood that the model code of conduct restricts only policy announcements that may unduly influence voters, not the routine functioning of the government. Essential services, welfare distribution, administrative decision, and ongoing projects continue uninterrupted. The true question, therefore, is not whether governance halts, but whether governance should be expected to operate without periodic accountability to the electorate. Frequent elections are not merely a cost. The other issue is whether financial burden. It is not merely a cost, they are check on power. They remind governments that the people are watching, evaluating, and free to respond. If elections are secularized, accountability becomes periodic rather than continuous. A government that loses popular confidence early in the term may find itself insulated under the, until the next synchronized cycle. This concern becomes particularly significant when we consider the interaction between synchronized elections and Article 356. If a state government collapses 3 years before the synchronized cycle, should the state continue under president rule until the national cycle catches up? Should it hold truncated elections? Should it install an alternative government? Without a bill, attempts to address this by providing that elections held after premature dissolution will fill only the remainder of the centralized term. But such a truncated terms may undermine long-term policy continuity. A government with a mandate of only 18 months may hesitate to undertake reforms requiring sustained political capital. Administrative reforms, economic initiatives, infrastructure projects, and institutional restructuring often require stability over extended periods. Shortened tenures may inadvertently incentivize short-term governance, categorized or populist policies rather than structural reforms. If in a synchronized election model, campaign strategies will undergo dramatic transformation. National campaigns would dominate the electoral space. Large parties with centralized organizational machinery would possess inherent advantages. Smaller regional parties might struggle to maintain visibility against the overwhelming backdrop of national discourse. This raises an important constitutional question. What is that important constitutional question? Should structural electoral design disadvantage one category of political actor over another? The framers of the Constitution did not intend for the structure of election to determine political success. They intended that success emerged from the free choice of the electorate, uninfluenced by structural biases. The role of Election Commission of India also acquires unprecedented significance. The Commission would need to ensure that political actors do not exploit logistical bottlenecks. It would have to prepare for contingencies such as natural disasters, security threats, or administrative disruptions that could render synchronized polling impossible in certain regions. Another aspect requiring reflection is the increased risks of electoral interference or misinformation campaigns when elections are synchronized. In an era where communication networks can be weaponized to spread misinformation, synchronized elections create a single moment of vulnerability. At this, any reform must therefore consider to birth security, media ethics, and digital literacy as central components of electoral integrity. At this point, it becomes necessary to turn once again to constitutional philosophy. Democracy does not exist solely in institutions. It exists in the habits of the people. It exists in their participation, their deliberation, their capacity to evaluate government at different levels. The Constitution reflects this through its commitment to decentralization. Panchayats, municipalities, state assemblies, and the parliament each embody levels of democratic engagement. Furthermore, synchronized elections may alter the internal functioning of political parties. Parties may prioritize national campaign themes and allocate resources accordingly. Candidate selections may become centralized. Grassroots leaders who derive their legitimacy from local context may find themselves overshadowed. The internal democracy of political parties, a crucial but often overlooked pillar of constitutional democracy, may be affected by shifts in electoral strategy. We must also reflect on the constitutional symbolism of elections. Elections reaffirm that sovereignty rests with the people. Every electoral cycle renews this affirmation. When the cycles are decentralized, the affirmation is continuous. When cycles are unified, the affirmation becomes episodic. Whether democracy is better served by continuous reformation or periodic reformation is a question that merits philosophical consideration. Let us now consider the implication for marginalized communities. Elections offer platforms for their voices, grievances, and aspirations. Synchronized elections may compress the political space available for community specific discourse. Regions with special need, such as tribal areas, border districts, remote rural belts, may lose visibility in the national electoral narrative. These are the greater issues which has to be decided, that it cannot be lost sight of. The Constitution demands that political structures amplify, not diminish, the voices of the marginalized. Their voices have to be raised. A further point arises for determination. Suppose a state or even multiple states face natural disasters or law and order crisis during the synchronized cycle. Should an action be postponed in these states? If they are postponed, should the entire national election be rescheduled? In many states, what you find that natural calamities occur. कहीं पे बाढ़ है, कहीं पे भूकंप है, कहीं पे कुछ भी है. So whether elections in those states should be stopped, whether the elections in the nation should be halt, these are the issues to be decided, taking into interest the marginalized class, the habitats of those states. This reveals if only those states are delayed, the synchronized model collapses. This reveals a structural fragility. The framers of the Constitution designed electoral processes with resilience in mind. Flexibility is essential in a nation as large and complex as India. The amendment bill anticipates some of these issues and places significant reliance on Parliament to frame laws under the revised Article 327. If synchronization requires rigid structures that compromise federal autonomy or parliamentary responsibility, no legislation under Article 327 can cure that infirmity. Now, the judiciary. The judiciary too must be prepared for new categories of litigation. Questions may arise regarding the validity of truncated terms, the premature dissolution of legislatures, the constitutionality of corrective mechanism, and disputes over alignment procedures. Courts may be called to decide whether the synchronized model is being implemented in a manner consistent with the Constitution. So, courts have also a great role to play. It is duty of judiciary and the courts to look into these things. This will require nuanced judicial reasoning grounded in constitutional morality and the basic structure doctrine. In contemplating all these questions, we must recollect that the ultimate objective of electoral reform should be to deepen democracy, not to streamline it. Reform must empower the people, not silence complexity. Reform must enhance accountability, not dilute it. Reform must strengthen federalism, not centralize politics. Reform must preserve the spirit of constitution, not compress it. It is in this spirit of careful balancing that we must now turn our attention to the ethical foundation of electoral democracy itself, to the philosophical meaning of federal autonomy, the jurisprudential position of the judiciary within a synchronized electoral framework, and the potential impact such a transformation may have on the very process of constitutional amendment.